Hi, this is the business guy, the CEO of Asset Protection Planners. How do you employ asset protection during a lawsuit? The answer is that you must make it more expensive for the plaintiff to sue you than the benefits they seek. And one of the most effective ways to do this after you're sued is to use an offshore asset protection plan. And the following discusses the reasons why. Cost versus benefit to your creditor. Mounting a legal case in these offshore havens can be an extremely expensive undertaking. Belize, for example, demands a bond of 50,000 Belizean dollars, roughly 25,000 US, or 50% of the amount claimed, whichever is greater. A case against a Nevis trust requires an EC $270,000 bond or US $100,000. A 2018 amendment to laws changed the LLC requirement to an amount established by the Nevis High Court, but the bond to litigate a Nevis trust remains at 100,000 US dollars. Other jurisdictions, not all, have similar bond requirements. A Cook Islands Asset Protection Trust has the longest, strongest case law history. In fact, our firm is the largest asset protection firm in the country, and we've set up more Cook Islands Trust than anyone in the world. We have attorneys on staff who you can speak with right now if it's business hours, or fill out a free consultation form on our website. In the Cook Islands, there are legal provisions that can protect assets immediately. And after a year of the assets being placed in the trust, courts won't even entertain a case from your opponent challenging the transfer of assets into the trust. A creditor will need not only determination to pursue a case in these offshore jurisdictions, but very deep pockets as well. And it would be swell if you could help me out by clicking the like button below so YouTube promotes this video. Thank you so much. And if you're new here, join the family by clicking the subscribe button below so that when more videos come out like this, you'll be up to date right away. In addition to a cash bond, a creditor is also usually required to retain a local attorney. Throughout the U.S., many lawyers are willing to work on a contingency basis. In most foreign jurisdictions, however, clients must pay their legal costs up front. In addition, if a creditor loses their case in the foreign jurisdiction, they feel an extra sting. He or she is also typically required to shoulder, partly or entirely, the winning party's legal costs as well. As if these expenses weren't enough, a creditor will also have to factor his or her own personal expenses during a lawsuit. This may include plane fares, extended hotel stays, and food. Then there is the car rental and other such unavoidable expenses. While staying in a foreign country, costs mount as the case proceeds. In fact, going offshore is one of the only strategies that can provide you asset protection after a lawsuit is filed. The expected cash outlay for pursuing a case against an offshore asset protection trust or LLC may tip the scales in your direction. It may be just enough to stop a creditor from coming after you in the midst of a lawsuit. After all, if they'll need more money to mount a case against you in a foreign land than they can reasonably expect to collect, then what's the whole point of taking you to court? Now, it may happen that a truly dogged creditor with deep pockets gets his or her day in a foreign court. By the way, in the 30 years I've been in this business, it's never happened to any client of ours. Anyway, let's say they proceed to prove that the assets transferred into your offshore trust or LLC were part of a fraudulent conveyance. This is by and large a civil matter, by the way, and not a criminal case. In such a very unlikely event, you would still be very well protected under this foreign country's laws. Even at this point, it's not as simple as it sounds. The laws in the offshore havens were written in a fashion to make them nearly as bulletproof as possible. Plus, their economies depend heavily on their financial services industries. Their judges know this and tend to rule accordingly. Moving assets during a lawsuit may arouse suspicion, but in and of itself, it is not automatically a fraudulent transfer, at least not in many offshore trust jurisdictions. In the Cook Islands, for example, a creditor still has to prove in their foreign court that the transfer was done with the sole intent to defraud them of the funds. And not just anybody, but that creditor in particular. Then the case has to be brought within a certain time frame of when the transfer took place. Moreover, the burden of proof is extremely high. A typical burden of proof in most courts is a mere preponderance of the evidence, say 51% of the evidence versus 49%, which is typically required in civil cases filed in American courts. However, in most offshore trust cases, your opponent would have to prove their case beyond a reasonable doubt. That's like 97% of the evidence versus 3%. This is the same burden of proof required in criminal cases in the United States. It's also the level of proof demanded for a case against a trust in the Cook Islands or Nevis Court. As stated above, this is an exceptionally high standard of proof. It is one that goes far beyond proving a claim based on the normal burden. Achieving this level of proof can be onerous and time-consuming, even if it's possible at all. Add to this fact that you are limited to using a local lawyer, and they may not be as experienced in producing this level of proof as some of the best legal minds in America. On top of that, like many lawyers in these jurisdictions, the attorney that your opponent hires may get most of his or her income from the offshore services industry. So think about it. There would likely be not much of an incentive for your opponent's attorney to create new case law that would hinder his or her future income. So sometimes just knowing that your assets are protected by an offshore jurisdiction, no matter when you put them there, may be enough to stop a creditor from filing a predatory lawsuit against you or continuing to pursue the case. Now, to be clear, as a defendant, you are not being encouraged to knowingly defraud the U.S. government. We are not suggesting you should shirk from settling a legitimate tax debt, for example. However, transferring your assets offshore is a legal avenue of relief from frivolous lawsuits. These are, unfortunately, on the rise in the U.S. and other countries. The best way to protect your assets after a lawsuit has been filed against you in your local court is to put them offshore in the proper legal tools. The most powerful set of tools is a combination of the Cook Islands Trust that owns 100% of a Nevis LLC. Now, the Nevis LLC, in turn, holds the bank account and investment accounts. This structure puts a company inside of the trust that you can control until the bad thing happens. When a legal challenge can result in asset seizure, that triggers an event where you would be better off to have our licensed, bonded, reputable offshore law firm / trustee step in to protect you. U.S. courts do not have the right to issue court orders in the jurisdictions where your trustee resides. As a result, actual case law shows that this structure has effectively shielded assets in one lawsuit after another. The most powerful set of tools is the combination of the Cook Islands Trust that owns 100% of a Nevis LLC. The Nevis LLC, in turn, holds the bank and investment accounts. Most foreign jurisdictions will consider a claim of fraudulent conveyance only within a highly restrictive time frame and very unlikely scenarios such as illegal activities. They are very debtor-friendly. Beyond this, such a transfer is deemed safe from a judgment issued by your local court. Additionally, a creditor must present his or her case to the foreign court. As we discussed, this can be tremendously expensive, both in terms of the bond requirements and other living expenses that will inevitably be incurred during the course of the trial. Finally, foreign courts demand a high level of proof beyond a reasonable doubt. This is difficult enough to achieve with seasoned U.S. trial lawyers, let alone an untested foreign attorney who may be disincentivized from penetrating a foreign trust. Pursuing a judgment against a defendant with assets that are in the proper legal tools under the protection of a foreign jurisdiction can be emotionally, physically, psychologically, and yes, financially draining. Sometimes just knowing that a defendant's assets are held in an offshore jurisdiction in the midst of litigation can be enough to deter a plaintiff from continuing to pursue his or her case. As a result, this leaves you, the defendant or debtor, keeping the bag full of your assets safe and sound even after being served with a lawsuit. Feel free to call us at 1-954-400-1050 or fill out a free consultation form at assetprotectionplanners.com. Please click like, subscribe, and text a link of this video to others. We'll see you next time. This is The Business Guy.